Hello everyone, I am Deepali Jadhav and today I am going to discuss on the topic termination of a contract. First, we will try to understand what is a contract. Indian Contract Act 1872 defines the term contract under its section 2 subsection H as an agreement enforceable by law. In simple terms, we can say that a contract is an agreement made between two or more parties in which a promise is made to do or provide something in return for a valuable benefit and which is enforceable by law. It recognizes and governs the rights and duties of the parties to the agreement. Contract may be written or oral, but many important contracts are often written and signed by both the parties. Now we will see what is termination of a contract. Termination of a contract means to end the contract prior to the parties performing all of their respective obligations required by the contract. Their duty to perform this obligation ceases to exist. The effect of termination is to discharge the parties from their unperformed contractual obligations under the contract. Termination of a contract may take place in number of ways such as breach of contract, impossibility of performance, prior agreement, rescission of the contract and completion of the contract. We will see these ways of termination of a contract one by one. First one is breach of contract. When a contract is intentionally not honored by one party, it is called breach of contract and it is ground for contract termination. Or we can say that breach of contract take place when a party fails to deliver on their contractual promises by failing to perform their obligations completely. In this case, non-breaching party may be able to recover the losses caused by the breach. Second one is impossibility of performance. A contract can be terminated when something unforeseeable occurs that prevent the parties from following through with the contract, and even sometimes a contract may become impossible to perform due to an unforeseen event after the contract was made. The situation is referred to as impossibility of performance and this may result in termination of a contract. Next one is prior agreement. Contract may be terminated by a prior agreement between both the parties. This agreement is in written form. The usual name for this type of provision is break clause. This prior agreement must give the details of what qualifies as a reason for contract termination. It should also state what action need to take place for one of the parties to terminate the contract. In most of the cases, one party must submit a written notice to the other party to terminate the contract. Fourth one is rescission of the contract. Rescission of the contract is another way of termination of a contract because an individual misrepresented themselves, acted illegally, or made a mistake. If a contract was formed under the condition involving mistake, misrepresentation, or a fraud, the contract may be terminated since it was not formed according to the sound contract principles. The last one is completion of the contract. Almost as simple as the last, a contract will naturally terminate when both the parties fulfill their obligation under the contract through performance. In such case, parties should keep the documentation showing that they fulfill their contract duties because documentation is helpful if the other parties try to later dispute the fulfillment of their contract obligations. A court of law will require proof of contract fulfillment if a dispute occurs. Now we will see what exactly happens when a contract is terminated. Contract termination can often result in several different legal consequences which may affect each party differently. If a contract has been terminated, one party has a legal recourse against the other party that breached the contract unless the parties agree to terminate the contract and release one another from their duties. Following are some of the remedies that may be awarded against the breaching party. First one is monetary damages. Monetary damages refers to the monetary payments which a breaching party has to make for violating the terms of the contract. These damages may include compensatory damages or punitive damages. Compensatory damages are those damages that helps to cover the losses of non-breaching party, and punitive damages are rarely awarded damages which may be given in addition to the compensatory damages to punish the breaching party. Second one is restitution. Restitution is a remedy utilized to restore the injured party to the position that they occupied before they entered into the contract. This usually means that the breaching party is required to compensate the innocent party by giving back any money or property they received from the innocent party. Unlike other money damages, restitution is not used to compensate the innocent party for any lost profit or other earnings that occurred due to the unlawful termination of the contract. Third one is rescission. Rescission is a remedy utilized by the court to terminate a contract when the parties enter into a contract because of mistake, fraud, undue influence, or duress. Rescission is also referred to as the cancellation or overturning of a contract. Fourth one is reformation. Reformation occurs when a court reforms or changes a contract to correct any iniquities. Reformation is utilized by the courts to rewrite an otherwise inequitable contract instead of setting aside entire contract. Last one is specific performance. Rarely, a court might order specific performance, which means that one party will have to perform their duties under the contract. Often, specific performance will only be ordered where money damages are not adequate to compensate the innocent or non breaching party. From the above discussion, we can conclude that contract termination is a drastic step and should be avoided if possible. However, there are times when termination is appropriate, such as when terms of the contract or the law allows for the termination, and it would also be the best way to mitigate the damages. Under these circumstances, the contract should be terminated with caution and with good legal advice. From the above